It was almost a 4-hour marathon session of a hearing about Rafale in Supreme Court today, which saw 4 top officers of the Indian Air Force come in to answer questions that the Chief Justice of India-led bench had. Air Marshal Anil Khosla, Air Marshal R. Chaudhary, Air Vice Marshal T. Chalapati, Air Vice Marshal Krishna Ayer were all called in because the judges wanted to hear the opinion of officers and not from the lawyers or from the Defence Ministry bureaucrat. The hearing to decide whether the demand of opposition leaders and of other petitioners asking for a special investigation into the prices of Rafale deal was valid or not ended with a reserved order. But at a time when this has become the #1 issue for the opposition to attack the government leading up to elections, and an issue which seems to be so complex, there seem to be new details emerging all the time. What we on Reality Check are going to do is to help you make sense of it. So let's look at the first detail which emerged today when the Attorney General of India, K.K. Venugopal, was arguing for the centre and Prashant Bhushan for the petitioners. What we learnt is that there appears to be no guarantee in place for the deal. The court asked the centre, if Dassault doesn't deliver, who will be responsible? Now, Prashant Bhushan pointed out that it was part of the Law Ministry's objections that if there is arbitration, it would be in Geneva. Now, the court asked the centre, why was there no sovereign guarantee from France? In response, the Attorney General said that a letter of comfort had been given by the French president. So that's something we have to figure out. This letter of comfort, the difference between that and a letter of sovereignty given by France. Where does it leave India? The other development was what the Air Force officers revealed about the necessities. Remember, one of the major factors in this deal has been that the government says UPA was dilly-dallying on it since 2007, and so because there was such an urgency, NDA announced it in 2015. The issue in all of this is that while till 2015, India's own Hindustan Aeronautical Limited was always in the picture, the court wanted to determine what made the MOD suddenly leave them out of this deal. So they asked serving Air Force officers about HAL's capabilities. They said Sukhoi 30 and light combat aircraft has been manufactured in Bangalore. Technologies are crucial, electronic capability enhanced in later generation. From 1985 to 2018, there has been zero addition of fighter aircraft. Remember, this is an assertion that has been made by the Air Force officials in court today. They've said there's been zero addition to the fighter aircraft. And so this could be a significant statement which helps the court make up its mind about whether there should be a probe or not. And the Attorney General added to the officers by saying HAL was not able to achieve the competence that was required in this. The Attorney General said that the Rafale would have saved lives in Kargil war. Of course, the court didn't seem impressed with that. They remarked Kargil was in 1999 and Rafale came after 2014. These are just some of the points that have come out. And to make sense of these kind of new developments and new assertions that are being made by different parties, in studio we have Saurabh Joshi, who's the editor of Stratpost. He's a defense analyst. Representing the Congress, we have Dr. Gaurav Vallabh. He is the spokesperson there. Taking the other point of view, we have Deshrat Nigam, who's not only a political analyst, but also a lawyer. And one of the key bureaucrats who have now written a letter, a group of bureaucrats have written a letter to criticize how CAG hasn't come up with its report on it. Jauhar Sarkar, the former CEO of Prasar Bharati, he joins us from Kolkata. I just want to take the first talking point on this, the assertion that there was no sovereignty letter or guarantee that has been given by this. Saurabh Joshi, I want to start with you because you're not the politician over here. How significant is this statement, and what is the difference between this other thing that we have and this letter of sovereignty that we needed, that the Law Ministry said should have been there, and now we are being told that the government actually got a waiver on these necessities. Otherwise, this was supposed to be definitely there, but the government got a waiver. Are we losing out on anything by the fact that we don't have this?
Well, thanks. The significance of this is that this letter of comfort or comfort letter is this something that is standard practice between within intergovernmental agreements? For example, when we concluded the IGA for the S-400, would we have been satisfied with a comfort letter? This is not standard practice. So then it leads us to the question, does it affect the agreement in such a way as to make it no longer a government to government deal? That is something that the Supreme Court has to look at now, as to whether the effect of this letter of comfort versus a sovereign guarantee means that it can no longer be considered a government to government order. That's the problem here.
Am I right in assuming what has been argued by Prashant Bhushan in court, that what this means is that if there are problems, if Dassault goes back on some agreement which has been there, then we can't go to France and complain about it, that basically it's for Dassault and Indian government to sort it out, which is a private company, and we'll just have to sue them in Geneva.
Well, yeah. So, according to what has emerged in the last couple of days, is that the responsibility for the execution of the order on the French side has been jointly and severally devolved to the government of France as well as Dassault Aviation. Now, it depends. What sort of responsibility would the French government accept for itself, given that it was only willing to issue a comfort letter and not guarantee it on the basis of the Republic of France, as the Republic of France? So effectively, you're stuck with Dassault. Okay. Now, then the question is, there are other issues also that have emerged in terms of where is the arbitration going to be?
That's right, which is what they were asking. Is it going to be in Geneva?
Right. So there appears to be these things would have been to the advantage of the government of India, that they're not part of the intergovernmental agreement.
Right.
Is a problem.
Deshratna Nigam, it is a problem. It is being said right now. These are issues that we are now realizing that the law ministry raised them, and it was only after much negotiation did the defense ministry finally agree with the law ministry on some of these issues. But France said no. They didn't want to be tied in by that. Doesn't that show that there are problems with this?
I think you're presuming so many things. It's all in the speculating.
I'm not asking.
No,
I'm saying this is
law
what the
ministry,
judges are asking.
No, law ministry said that. They said it.
No, this is on paper. This is not being disputed by the Attorney General in court.
No, the stand, see, even the Attorney General says what has been given in the sealed cover, he has not perused it. He's been very clear.
No, that is just the pricing. Let's not get into these
about
things.
the contracts and everything,
right.
Offset contract and everything have been given in a sealed cover. So we don't know. We don't even know the language of letter of comfort. And there is an arbitration clause. But one thing I can tell you, when there is a clause as a lawyer about joint and several responsibility, which means government of France is equally responsible, either both of them or single can be held responsible. This is the meaning of joint and several. That is what the law says, and therefore both can be sued if they do not perform the part of the contract.
No, the question is that instead of a sovereign letter of guarantee, we were given a letter of comfort. And there was no response that the Attorney General had when they were asked questions of what happens when the arbitration is there, do we have to go to Geneva? There was no response to that.
There cannot be, because Attorney General
is not privy to it.
No, not privy to it, and they are apart. Once they read the contract, the specific clauses of the contract, these things will come out in public domain. Because I only, very limited discussion took place on the contents of the contract, offset contract. But once you say joint and severally responsible, that means either or both can be held responsible and sued.
Okay, Gaurav, what do you see as the main problem with this particular aspect?
See, there are three issues on which Supreme Court had asked and what Attorney General had responded. I will share three broad issues.
Can you
first
can you first limit it to this particular aspect, Gaurav Vallabh? Just for the Gaurav Vallabh, sorry, I'm interrupting just for the clarity of our viewers. Let's respond to this one first, and then we'll go by point. We'll handle all of that. Can you just respond to this particular aspect so we finish this and move on to the next one? Thanks.
Correct. Can you imagine that 60,000 crore rupees plus of the deal, when government is saying that it's a G2G deal and there is no sovereign guarantee? can you give me any instance in the past when there is a G2G, government to government deal, and there is no sovereign guarantee? And letter of comfort is a comfort letter, and this is between government of India and Dassault. So where is the France government? I am asking. So, and Mr. Nigam, he himself is an advocate. I am asking Mr. Nigam, do you, by saying all the arguments I am hearing very patiently, do you mean to say that letter of comfort and sovereign guarantee is the same thing? Why you want to befool the country? When it is G2G deal, people wants to know if there is some fault, if there is some dispute, then government of France is nowhere in that. It is between government of India and Dassault Aviation, and in Geneva courts, the things in the arbitration court, the things it will be decided. This is not something which we expected in any G2G government to government deals, first thing. So this is our first question. If you want me to question second and third thing, I am open. Can I move to my second question?
No, I'll come back to that. You will get to. I just want to go raise some of the issues point by point, and then you can add all of those points as well.
Okay.
So second point, and that's where I want to go across to Johar Sarkar, is that many people, Johar Sarkar, are a little uncomfortable, and they say this may be, what kind of a trend is this, that we have all senior officers, they are being asked to comment and give their opinion on something that has become so contentious. Something that seems to divide people, that people, the same facts are there, but everyone is reading it differently. In the midst of that, the court, of course, asked the top 4 very senior officers of the Indian Air Force to come in there and give their views, and they said that they had, and it seemed very clear what their opinion was, they said we needed these acquisitions. Do you think, are you comfortable with that?
No, not at all. They see, the precise reason why we raised this issue is that there is a lack of transparency throughout the deal. It's incumbent upon the CAG, and that's our limited point, to come out with the facts as are available in the public domain and examine them with the same thoroughness with which it has examined past cases. All we are saying is we need more light, not heat. And in order to reach that light, we need the CAG, the institution enshrined in the Constitution, to be allowed to go through it without pressures, if any, and come out with the facts. All debates can take place only after the facts are there on the table.
Okay.
We are distressed at the delay that the CAG is taking.